Next, we'll move on to item number 45, which is, this is just a warning that that's the item we're going to take up right now. Consider status report regarding release of the draft environmental impact report on the proposed cannabis commercial cultivation and manufacturing regulations for public review and comment as outlined in the memorandum of the planning director. Or maybe this is the actual correct title is presentation of the draft environmental impact report on the proposed commercial cannabis cultivation and manufacturing and licensing program. We will be hearing a presentation. We will be asking some questions, and we'll see who wants to testify after it's over. Good morning.
Good morning, Supervisors, Chair Leopold. I've got a presentation to go over the commercial cannabis cultivation, manufacturing regulations, and licensing program.
You might want to start with introducing yourself.
My name is Matt Johnston.
Okay.
I'm a environmental coordinator for the planning department. And I'll just jump right into it. The purpose of this session is to describe the structure and the findings of the draft EIR to facilitate your review and ultimate adoption of policies and regulations. A little background on how we got here. There's much more background than this, but this is a brief summary of the last few years.
Some of us have lived it. Some of us have lived it.
Some of us still remember it. In September of 2015, California established MRSA with the medical cannabis cultivation. In response to that, we adopted, your board adopted Santa Cruz County Code, Chapter 7.128, which established an interim licensing program. In 2016, we started to prepare the proposed permanent licensing program, which is the subject of this EIR. Also in 2016, the state legalized cannabis for recreational use. And so as we move forward, the EIR and the regulations that it analyzes will consider the permanent program pursuant to the to MRSA. We'll go with MRSA. This is an overview of the proposed regulations and licensing program. The program establishes criteria to license commercial cannabis cultivation and manufacturing. That criteria is based on zone districts, on parcel sizes, location, the intensity of development, and it establishes design criteria for the different cannabis sites. The regulations for site development have been developed to be as consistent as possible with the code, although they do involve modifications to the code as either amendments or recommendations for you to consider. This EIR does not look at the personal use, it only looks at the commercialization of cannabis. So personal grows were established, and I think you've adopted already regulations concerning that. Cannabis cultivation in your proposed project allows cannabis cultivation on residential, agriculture, special use, timber production, agricultural and commercial agricultural properties, service commercial and industrial properties. It is not allowed in residential R1 properties. Development standards further restrict the eligibility based on setbacks from various resources. And as you go through the regulations, you'll see many setbacks, many conditions under which it can be, properties can be developed. This EIR looked at a two-program scenario. Your original project and during your board deliberations, you asked for, and we've tried to provide a range of alternatives, a range of opportunities for you to select from to create the most appropriate regulation. In this EIR, we looked at your project, and then we developed through staff and the consultants a slightly more permissive project to expand some of the areas, to give you some opportunities, reducing some of the buffers around the coastal zone and reducing parcel sizes, increasing canopy areas. This is just to give a more broad analysis of what options are out there. If you look at the map, this map shows the project scenario under the proposed ordinance that your board approved as a draft. You can see the coastal zone is the blue line running north to south, west to east, with a 1 mile buffer. In the yellow, that would be the second district, which allows for no outdoor growing. Looking at the more permissive project, you can see the yellow is turned to green. That means cultivation is allowed indoor and outdoor. And the 1 mile buffer is no longer a restriction.
The green areas are the areas that would be eligible in this more permissive project, and you can compare that to the previous slide and see that there's approximately 2,000 more acres of property that becomes eligible or moves into the eligible category in the more permissive scenario.
Go back and forth between those a little bit. When it comes to cannabis manufacturing, we have a proposed ordinance which would allow it in the areas where cultivation is allowed. It would also allow it in community commercial, only in conjunction with an established dispensary. The types of manufacturing are, there are 4 different types of licenses ranging from steeping to high pressure and volatile chemicals. So there will be 4 different types of licenses. It would be a requirement that it would be ancillary to cultivation in agricultural and timber zones. So you'd have to have a grow. You cannot do manufacturing if you do not have a licensed grow. The proposed ordinance would also allow single detached family homes in residential settings to have a home occupation. This would be for the lower intensity manufacturing, would not allow for the high intensity, the types of manufacturing that tend to explode would not be allowed in the residential. So what is an EIR? This EIR is an informational document. It's designed to bring as much of the best available science that we have and knowledge that we have about this, the cannabis community and the existing community and what we project it to move towards. It identifies potential impacts from this project. It identifies mitigation measures to reduce or avoid these impacts, and it describes feasible alternatives. All of this ultimately will be certified by your board prior to the project approval. The EIR does not approve any project. The EIR is purely so the decision makers, your board, can deny or modify a project, even if no impacts are found. You have the authority to craft the regulations as you see fit based on the best knowledge available. Where significant impacts are identified in the EIR, mitigation measures must be considered to avoid or reduce the impacts. Where they are identified and feasible mitigation is not available, you make a finding of overriding consideration. This is a diagram of where we are in the EIR process, and basically we're pretty much smack in the middle. We've gone through the notice of preparation, had public hearings to create documents to look at the scope of the EIR. We've produced a draft EIR that is now in the 45-day comment period. Once that comment period is over, we will take all the comments that are received. We will provide responses to those comments, and we will provide a recommended final proposal. Once that's done, you'll have a chance, both the Planning Commission and your board will have a chance to review those, accept comments from the public. You'll have a chance to review all of the comments that come from the public as well as from your commissions who have heard. We've given presentations to various commissions and are available to respond to them as they have further questions. Taking all of that information together, you'll be expected to make a final decision on where you want to take this program. The scope of the EIR considers potential physical impacts of the following actions. The adoption of the program, which includes amendments to the Santa Cruz County Code, amendments to the general plan and the local coastal program, and licensing of commercial cannabis cultivation and manufacturing activities. In order to evaluate the potential impacts, the first step was creating an environmental baseline. That baseline is set with the initiation of the notice of preparation. That was back in February of this year. And at that time, that is the the date for CEQA of the baseline. And that baseline was, in this case, very difficult to set. This is an industry that has been in the shadows, and getting hard data on what exists out there is very difficult, particularly with manufacturing. We relied on the licensing registration data. There was a registration period where anyone who had been cultivating for 3 years could apply. There was a manufacturer's survey conducted by the licensing department of the manufacturing community. Interviews with the cannabis industry representatives formulated a lot of the information. Sheriff's Office, code enforcement, local industry, other communities that are doing these EIRs and having those. We've been in conversation with Humboldt and other counties who are going through the same process. And there was a local industry study that was done as well that helped shape some of the knowledge that we have about the existing baseline. The EIR's purpose is to analyze the changes from the baseline. So we recognize there is a large cannabis community. Under our existing code, it was illegal, but as long as they were following the rules, there was limited enforcement. That's created a situation where you have people who have been quasi-legally growing, who are now going to try and become legal. The change from who is growing now to who grows in the future under the legal regulations, that's what we're analyzing in the baseline, from the baseline. So an EIR looks at various types of impacts, of levels of significance. The most significant ones that cannot be avoided. There are less than significant ones that can be mitigated. There are impacts that we recognize but that are not of a significant level. There are some actions which have no impact, and there are definitely beneficial impacts to implementing a program such as this. In this EIR, we address the direct, indirect, secondary, and cumulative impacts. I'm going to take a minute to talk about the secondary impacts. Secondary impacts are difficult to explain. The program, as it currently stands, changed from the baseline. When you initiate a program such as this, there is some implication that there will be further licensing. So there's a potential for this program, by establishing a regulations around this, more people can come in and feel that they have an opportunity to get established, and we can see another green rush as a result of implementing a licensing program. People, when we first had the limited immunity ordinance, we saw a massive influx of out-of-state people buying properties and starting to cultivate. So there is the potential for that to happen with a regulation. Beyond that, there are people who were growing illegally or legally, quasi-legally under our existing ordinance, that may not be, for whatever reason, once your regulations come out, may not fit under those regulations. And those people who were considered part of our baseline will now be part of the underground community or the black market. So those are the secondary impacts that we're looking at, which is an increase, a continuation and an increase of the black market. When we're looking at the summary of all the environmental impacts, if you have looked at the EIR, there are 31 pages of mitigations in Chapter 6. I'm going to briefly go through each of the areas, and then I'm going to spend a little time speaking to some of the major impacts and the mitigations that we formulated for it. There were impacts associated with the aesthetics and visual resources, primarily around fencing and the light and glare. Agricultural and timber resources were looked at, particularly for conversion, both of agriculture and timber resources. Air quality had issues, obviously, with odor. That's one that you'll hear over and over. But beyond that, emissions from vehicle trips and emissions from other uses on site. Biological resources, you'll see it is underlined, and the ones that are underlined are the ones that I'm going to touch on later. Obvious impacts with biological resources, that's one of the reasons we're having this program, is because of the impacts that have happened to our hills, the widespread clearing in all sorts of habitats. Cultural resources were looked at, particularly with regard to historic buildings and the reuse of historic buildings. Geology and soils, there's a lot of grading that goes on, not only primary impacts from the clearing of a site, but with requirements for meeting code standards and fire standards. There's impacts to creating these roads and building pads. Greenhouse gas emissions relates, again, to energy use is one of the hot topics for indoor use. Indoor grows can have consume a lot of energy. And so we looked at the energy use both of indoor growing, but also of vehicles traveled. Hazardous and hazardous materials, with any agricultural project, you have rodenticide, you have pesticides, herbicides, chemicals. The manufacturing has high pressure systems that are hazardous, so we definitely address those. Hydrology and water quality, both from a water quantity and quality standpoint, are looked at, and I'll talk in detail about that. Public services, fire protection, law enforcement, public parks, these are all addressed in the chapter on public services. Population, employment, and housing was a little surprising. The amount of jobs that this industry is projected to create is quite substantial. Over 7,000 jobs are anticipated to be created through primarily the manufacturing, but manufacturing and cultivation. Transportation and circulation is one of the areas where we had significant impacts that are unavoidable, and I'll get into that. The utilities and energy conservation includes both water, wastewater, and solid waste, and energy infrastructure. There's a robust conversation, and I urge you to read that chapter. There were two chapters where we found that the impacts were not significant, primarily in noise with the restriction on generator use, which is one of the primary noise factors associated with the grows, and then the minerals. We found that we're not having any impacts on mineral resources. So, with some of the mitigation measures and some of the impacts, the primary way to address with the biotic resources, the way the licensing department is set up, there will be a pre-screen of every site. Licensing staff will go out and look at the site to make a determination whether there are or are not sensitive resources on site, whether that be a stream, sensitive habitat type, habitat for a listed species. In that case, once the assessment is done, they'll make that determination, and if it is present, a third-party biologist will do an assessment. That assessment will then come to the planning department for review, and once approved, the conditions under that assessment establishes to avoid those impacts will be implemented. So that's our primary way of dealing with impacts to chaparral or oak woodland, or in particular with oak woodland and sand hills. Oak woodland is the primary habitat for the long-toed salamander. So in salamander habitat areas and in the sand hills, which are probably our two most rare habitat types, if there is ground disturbance associated with it, there will be a denial of the permit unless there can be mitigating factors that a biologist and the licensing official can work out. But the initial response is, if you're going to disturb ground where there might be salamanders, where there might be June beetles, we're not going to allow it. That is a limited area of the county. That is the Sand Hills, and primarily in the 5th District, the Larkin Valley to the Salamander Protection Zone around Bonita in the 2nd District. 2nd District? With regard to water resources, water is a huge factor in this industry. Primarily because the industry is established. Obviously we have an existing agricultural industry that's been here for a long time. It has its known water woes with the groundwater depletion in the Pajaro Valley and in other watersheds. But this program is recognizing perhaps grows in more remote areas where water is not necessarily as available. It's not on a municipal system. You don't have the flow rates necessary to meet fire standards. So water is going to be required at every grow site to meet fire code standards, provided there is some structure, commercial or industrial use. And most every structure associated with commercial cannabis creates an industrial use. So the way we've worked with the state, and there will be a meeting in a few days to actually sit down with the state agencies on their regulations, and we continue to work with the state on what their requirements will be for water. Some of the mitigations that we've put into place, or that we're recommending, in any fish-bearing watershed where there's a connectivity between your well or your diversion, you're not allowed to draw water during the summer months, only during the winter months when water flows are high. This is echoing a state requirement, so we got that pretty much straight from what the state is going to require. Beyond that, we want to maximize water catchment from rainwater harvesting. There will be requirements for as much as 120 to 160,000 gallons of water to be available for cultivators for fire. A fire hydrant has to have a certain amount of flow for over a certain amount of time, and depending on the resource, that can be up to 160,000 gallons. Beyond that, you're going to have a house on site, so you're going to need fire requirements for the house use, just a regular water use for the house, and your irrigation water. So there will be a lot of requirements for water, and we're trying to mitigate that by, again, maximizing rainwater harvesting based on total roof area and projected demand, encouraging the shared use of infrastructure. One water tank can serve multiple farms. It's a lot cheaper and less impactful to have a quarter mile of pipe from one tank to a nearby property. And the licensing staff will work with the various cultivators to maximize that to them as much as possible. And then water efficiency standards when you're doing any type of cultivation. And in doing the analysis for this EIR, we really looked at how much water gets used by cultivators, and it's all over the map. There are people who are growers who are on the same stretch of the same road who one might use 10 times the amount of water as the one next to them. And yields are comparable. So it really comes down to the maximizing the efficiency of water and allowing the industry to adapt to a very water-poor process. Another impact associated with the water requirements, with the fire code requirements, and those drive a lot of the impacts. Fire code requirements for the F1 occupancy structures require a 20-foot wide road with very large turn radiuses to access from the county right-of-way to the building. This can result in massive amounts of grading in some of our narrow canyons. Some of these roads are on steep slopes where you've got to drop off on one side and a 12-foot wide road. To make that 20 feet wide can create a massive amount of grading, and there are people out there with the finances and the resources to do that. We've made a determination that in some cases that's not necessarily appropriate, even if it's affordable. In order to minimize the grading, we're asking for a revision to the grading ordinance to allow for, in certain circumstances, under certain parameters, a denial of a permit based on excessive grading. We hope that will limit a lot of the potential damage that a lot of these roads, new road cuts, can do into the deep hearts of our mountain. In terms of energy use, there's and this was appropriate, earlier in this hearing, the Monterey Bay Community Power is one of the primary mitigation measures to reduce carbon output. We do have a mitigation that requires a carbon neutral plan, and that can be done through Monterey Bay Community Power. They will have an option, and it should, provided that the assembly measure does not go through, that puts a halt on it, that will allow people to buy 100% renewable, off of 100% renewable energy. Beyond that, we're going to maximize on-site alternative energy sources. If you're building a new structure, we're going to require solar power. If you're retrofitting a structure, we're going to strongly recommend it. We recognize people are leasing buildings and don't always have the opportunity to do that type of infrastructure change, but as to the maximum extent feasible, we're going to encourage that. The other issue with energy use is transportation. The greenhouse gases produced by transportation can be quite significant, with over 7,000 new employees. That's a lot of vehicle miles traveled, a lot of trips. So we've included a lot of mitigations for Where appropriate, there are traffic impact fees, but to deal with the greenhouse gases, combining trips as much as possible, carpooling, having a shuttle, particularly for some of the more remote grows where you have seasonal workers coming in, have a shuttle stop and bus people up to a site rather than having a dozen cars on a small windy road. There are other mitigations in here, and I urge you to read Chapter 6 in detail. Those are all the mitigations. The best management practices covers a lot of ground on a lot of the different impacts, including maximizing energy efficiency, trash, water use. I believe there's over 20 different best management practices that have come from the agricultural community. So this is a summary of the various chapters. There were only 2 chapters where mitigation was not required, as I stated before, public services and hazards. Mitigations were required in almost every other chapter, And in 2 chapters, there was significant and unavoidable impacts. With air quality, those related to the trips generated and the air quality as a result of vehicle miles. While we can reduce those, we cannot fully mitigate for those. Beyond that, transportation and circulation, and this significant and unavoidable comes from the fact that we have multiple intersections around the county that are already at a level of service of F, that with a broad scope implementation of a project like this, we don't know where all these trips are going to go. We know that they will go through certain intersections, and those intersections cannot all be upgraded to a lower level of service. Therefore, we know there will be a significant unavoidable impact. In looking under CEQA, you're required to look at your project, and then you're required also to look at a no project alternative. And typically, a no project alternative is sort of a blank slate. If you're going to do a large medical facility and you're doing an EIR, you typically have a blank canvas to look at. And if you don't do anything, there's no impacts. This is a unique case in that the no project alternative is a continuation of our existing regulations, our existing limited immunity regulations, which create a very difficult way for enforcement to happen. When the sheriff comes out and they don't know whether someone is legal or not, it makes it very difficult for them to engage. So in this case, we looked at a no project alternative that looks at the continuation of our existing code going forward. In order to provide the spectrum of alternatives for you, we looked at an alternative 1, which is a most restrictive project, which really limits the amount of available acreage for cultivation, and a most permissive project. And so we've kind of got from the no project alternative, where you wouldn't be allowed, even if under the existing program, to grow more than 99 plants, and certainly would have a lot more regulations under our existing code. To the other end of the extreme with the most permissive project, which would allow for co-location of sites, exceedance of set limits on cannabis on a particular parcel, and as we go through, you'll see that this gives you a broad range of opportunities. You're not required to select one of the options. As you go through this and as you hear comments, you can select from the most permissive alternative. You could select allowing co-location, which brings people who cannot find a site, who are being bumped off of a site for whatever reason. It gives them an option to grow as a collective. You can also take the most restrictive project alternative and not allow cultivation in timber or SU zone parcels. So you can do a combination of any of the components of any of these alternatives. So right now we're in the public comment section period. We've got until October 16th at 5 o'clock for the planning department to receive comments. The comments should be on the adequacy of the EIR and the alternatives evaluated in the EIR, and they should focus on the environmental impacts of the proposed program. And I actually want to take a step back. There's one impact and mitigation that I really needs to be discussed, and that's enforcement. You're going to hear it over and over that if the planning department cannot enforce it, what's the purpose of the project? The enforcement is a mitigation that comes out of the secondary impacts, recognizing that we do have a black market community that is well established. The only way for this program to be successful for those who are putting in the time and money to try and meet the new regulations, both at our level and at the state level, is if we have adequate enforcement of the black market. To that end, there are mitigations in place or recommended that will monitor during the first year and evaluate the needs as we move forward. We do have 2 code compliance investigators in the licensing office. We have code compliance staff in the planning department that will be working in coordination with the licensing department. And that may not be enough. That may be enough. Over the first year or so of enforcement, after a year, we're going to come back, or the licensing department will come back with a report to your board to discuss further implementation or staffing or resources necessary to really make sure that we have enough to enforce on the black market, the black market community. Again, back to comments. Comments can be either submitted on by letter to myself, Matt Johnston, or there's an email address, as you can see on the screen, which has already started collecting comments. We've had a half a dozen already in the first week, and I fully expect there to be hundreds more. The next steps at this point, we're in the middle of the public review period. Once there will be a meeting on October 2nd to collect comments. This will be a meeting for the public to come and either give oral or written comments. There will be a published final EIR. Once we've gotten the comments, we've had a chance to formulate responses to all the comments. And we expect hearings in December and January on certification of the final EIR and action on the project. I want to thank you for your time, and we're available for questions.
Thank you, Mr. Johnston, and appreciate all the work that you and all the staff put into this. I want to just caution my colleagues and the members of the audience that today's presentation was just to fill us in on what was in the EIR. So our comments will be restricted to questions about any information in there or about the process. We are not litigating the what the eventual ordinance would be. This is not the time for that. So again, questions about the EIR or about the process are appropriate today. I just also want to recognize that Robin Bolster Grant, our new cannabis licensing official, is here, and other members of our licensing staff. I appreciate that, as well as Juan Hidalgo, our agricultural commissioner, and other members of the planning department. This issue has been taken very seriously by the planning department, and our board has identified that we wanted this highest level of environmental review. So thank you for the work. Now I'll turn to members of the board and see if there is any comments.
Sure.
Supervisor Caput.
You pretty much, yeah, we have permissive, a little bit alternative, and then one's more restrictive. It looks like you're encouraging the one that's more permissive, I guess. Okay, what I'm getting at is, if it's going to be more permissive, is it going to be county-wide, or is it going to be more in District 4, just because of the zoning, or?
So Supervisor Caput, that is not an issue of what we're going to take on today. I know it's very important to you.
Sure.
And I don't mean to knock its significance, but in terms of the EIR, it was an evaluation of what our existing rules are and some changes that could happen. So we're not deciding today what the ordinance is going to be, what area it's going to cover. The EIR presents us with options. Mr. Johnston and the rest of the planning department is not going to be making those choices. We're going to be making those choices. So I just wanted, that's why I put my, I preface this by saying we're trying to focus on the elements of the EIR.
I think, though, I could do a little bit better to explain the range and the difference between, and this is something that has brought a lot of questions up, permissive versus restrictive. As we go from along that scale, the permissiveness really is in terms of the parcel size, reducing parcel size or increasing parcel size, minimum parcel size, which obviously takes some parcels, smaller parcels, in or out of the equation. So permissiveness really is looking at either allowing more people into the program or restricting how much space there is for the program in the county. That said, there was not a great distance in the number of parcels and the acreage available. So the restrictiveness, it also, as we get to the more permissive, there are some other opportunities to allow an environmental benefit from bringing multiple growers into one spot rather than having them spread out. And when it comes to the recommendation, we're not recommending anything at this point. There is the result of the document was that the least environmental impacts come from the most permissive alternative. And that is primarily because of the co-location and because of the number of people it pulls out of the black market. And that's where we see this huge impact, is that black market. So the more people that get pulled in, the less impacts we will have, the less of the fires and the 14 people illegally growing in someone's backyard. So we will ultimately have a recommendation from the planning department as what we see is the best suited for Santa Cruz County. You are not beholden to that recommendation, and you will deliberate as to what the final determination will be.
Okay, the environmental impact is very, very important to Santa Cruz County. We're
Yes.
trying to protect what makes us special to live here. I worry about my area. I worry about District 5 up in the mountains there where the redwoods are and all that. If we reduced, we're talking about 600 plus pages here. I'm sure we've all read every page, and I think we need to add a few more pages. No, I mean, but anyway, if we reduce the parcel size, are we thinking about even considering changing that 5-acre minimum?
This is, yeah.
I just want to
Okay.
caution that the EIR looks at a number of different scenarios. It will be up to us to pick off that.
No, I
They are just,
understand
they are just looking. They are not telling us what to do, and they are not going to make the decision. It is we who are going to make the decision, and we're not doing that today. This is just about what's in the EIR. If there's questions about how we came up with that, how we developed
Okay.
that analysis, that's what we want to talk about.
Okay, what I'm getting at here is, with the environmental impact report, if we reduce a parcel size, we have something else that happens, because then if you get a smaller area, we have neighbors complaining. The closer you get to this growth by a neighbor who doesn't like it, that's environmental in itself, just by the living conditions. But when we're dealing with an EIR, we're not dealing really with people, we're dealing with the environment as far as the land around there?
The EIR does take into consideration impacts on neighbors. So the smaller the parcel size, the closer proximity you may have neighbors, and the more potential there might be to impacts to neighbors. But ultimately, the parcel size determination, you presented us with a parcel size determination in your proposed project. We tweaked that in terms of making the minimum parcel size smaller and the maximum canopy allowed on each parcel larger to provide an alternative, to provide something to look at. There is also an option in the more permissive one that on a case-by-case basis, if you have a minimum parcel size of 5 and you have someone coming in at 4.9 acres, that may be okay. So that's something that you can consider to allow. But ultimately, you will be responsible for determining what your minimum parcel size in each zoning district will be.
Okay, and then when it comes to ag land, that's commercial ag and ag. We have a lot of that in District 4. So the environmental impact on, let's say somebody has 100 acres of strawberries, but they want to pretty much put in, what, 10,000 square feet right in the middle of it? They wouldn't have to put up a fence, would they, around that if they put it in the middle? Because we're talking about quite a distance away from anybody.
The way that the proposed project came through, there was a requirement for a fencing around that. There is a mitigation to allow fencing to be reviewed by the licensing official to determine the appropriateness of fencing. So to allow for some flexibility in that type of fencing, so we don't have a single fenced area that has to be moved every crop rotation.
Yeah, and the motivation, I guess, what I'm worried about is the money. When we're done with all this, should the price on the black market, for that matter, or any market, should the price come down?
That's not considered in the EIR.
Pardon me?
That's not considered in the EIR. We don't,
That's right. But it has really a lot to do with whether or not we're protecting the environment. If the money encourages people to do it illegally, if they can't get into our permit process, it's kind of futile what we're going through, right? I mean, the price has to come down in order to, you see where I'm getting at?
That might be a rhetorical question, because I don't think the members of the planning staff are going to answer that, because that's not part of the EIR.
I do have the hope that we can put together a successful program.
Okay. And what I have told farmers, tell me if this is correct. If they're doing very well, they're making good money on 100 acres, do they really want to take part of that and put it pretty much in the middle of their farm? They'll get money from that, but they're also going to get more restrictions, more people looking at their land, more people going on their land. They're going to have, are they going to want that hassle? So what I'm getting at is the impact, the motivation. The motivation and being able to get more money, even if you're doing well, is it worth the more scrutiny they're going to be under? So that's outside of it also. I understand what you're getting at. And lastly, it would be the only motivation I really see from a farmer that's doing well the way he is would be maybe if you're facing a bankruptcy or you're actually losing money. So I don't know. Anyway, the last thing would be when we're dealing with District 5 mostly, redwood trees. What we're trying to do, it's still illegal just to cut down big redwood trees without any of this, right? That all comes under state regulation and everything.
No, the regulations around cutting redwood trees, it's illegal to convert timber forest without a state permit, but if you have a property that has redwood trees on it and you're not commercializing it, you can cut down a redwood tree.
Okay, but you can't just cut them down at random. You have to have a permit to cut them down.
It depends. That's a broader question. I don't think it really is covered under the EIR, but you will have, as a board, the opportunity to restrict cannabis from timber or not. Right now, it's considered an agricultural product, and our current code allows for agriculture on parcels zoned for timber.
Supervisor McPherson,
I'm
anything?
done. That's a big one for
Yeah, I
years.
just want to say, in general, we've been trying to get our arms around this for over 3 years now. And with conflicting state and federal laws, this is no easy task, and every county in the state is up against this to try to get it right. And I hope we can get it right, and I just want to comment and say thank you for presenting that good draft environmental impact report, I believe, that gives us a lot of options. And I want to thank the committees who have participated in this process over the years, as well as what we're doing here today. So thank you very much. I think we're going to have some solid information to make some good decisions in the future.
Supervisor Coonerty.
Yeah, I just want to briefly say, I think this is the moment, as our chair pointed out, for the community to really share your comments and questions and concerns. We will have plenty of time to review and then make substantive decisions that are in this document, but it's really important that we hear from the community, both in this room and then over the next period, that neighbors and residents talk about their experience, their concerns and their questions, and get them fully covered in this EIR.
I just had a couple questions. One, the job creation numbers were pretty amazing to me, I guess I would say. I hadn't expected that. I think when we got involved with this 6 or 7 years ago, that was not a consideration. Could you just go through just briefly how you came up with that 7,000 number?
Kathy, do you want to take that one?
It was, the EIR consultants surveyed and interviewed a number of existing cultivators and manufacturers. One of the outcomes of this EIR analysis was a greater understanding that there will be a relatively small amount of cannabis grown outdoors. And so most of it, the cultivators want to be indoors in either buildings or in greenhouses or what we call non-traditional hoop houses, where they've got lights, they're ventilating and everything. And those are getting on average 3 crops per year. And there is a lot of employment associated with growing, drying, trimming. A lot of the cultivation sites also have certain manufacturing activities going on also on the sites. And we were surprised as well that it was that much employment. But one of the questions we've had for quite some time is, what is the size of the industry? How much is being grown now? How much wants to be grown in the future? It's a very difficult question to answer. The methodology of the EIR basically was based on surveying registrants. And what we learned was that the 760 active registrants have expressed a desire to grow a total of 43 acres in the future. Of course, existing farmers who had grown 3 years prior to registration were not required to register. So then we had to come up with some sort of an estimate on how much cultivation is likely to occur through existing farmers. The answer to that question is, we looked at the 2015 crop report, and due to the waning cut flower industry and potted plant industry, there's a lot of unused and underused greenhouses, mostly in ag land in South County. And so the assumption was made that up to 75% of greenhouses that had traditionally been used for indoor cut flowers and indoor potted plants could convert to cannabis. That was a total of 147 acres. So the analysis projects up to 190 acres of cannabis might be grown in the future. And that is associated with a fair amount of employment. And on the manufacturing side of things, as Matt explained earlier, there's 4 different classes, low intensity, low pressure, crock pot, tinctures, all the way up to high pressure, high volatility processes. So we differentiated that by smaller, lower yield versus, larger, higher yield. And the larger, higher yield can attract a fair amount of employment. And I'm trying to remember the projection. We projected that up to 400 new cannabis manufacturing businesses would establish within the first 5 years. Not all large, but that as the industry begins to stabilize in about 5 years, with all the other jurisdictions that are going to allow this activity, there's going to be people coming and going, and we project stabilization in about 5 years, and that with an additional 1,200 employees associated with manufacturing. We assume that half of those employees are also employees involved with growing cultivation at cultivation sites. Anyway, that's a long answer to a complicated question.
Yeah, no, it was, and it was one of the very interesting parts of this report. There were many. I've spent a lot of time with this report. I can say I haven't gotten through every chapter. I think I still have 5 and 6 to go. But as I looked at it, you know, obviously, greenhouse gas emissions from this increased employment, you know, that's why that figure is so important in this. And as I looked at the mitigations proposed, I know that we could add on to these, you know, because I would say incentives for using low emission or zero emission vehicles as being one of those places. You know, I think that's very real, whether it be electric bicycles or electric cars. You could have low emission vehicles, and you still have them on the local streets and roads, but they aren't generating emissions. So that might be something to look at down the road. The other question I had is, there was the mitigation measure around historic assessment of structures 50 years old or more. And the question I have is, why 50? My house is 50 years old, and I don't think it's historic. Maybe when my daughter gets elected president, they'll make it historic. But there's a lot of housing stock like that. So could you explain why 50 and not something else?
50 is kind of a well-established threshold for looking more carefully at the potential resource value of a structure in the historic resource community, and the state standards include that 50-year threshold. And what we do in the planning department is we take structures that are more than 50 years old, and we run them through our sort of first-level process to see whether any of the other criteria for being a historic resource are met. So just being 50 years old doesn't make it historic. But you know, that's kind of a rolling threshold over time, and there are some kinds of architecture, for example, like mid-century modern, that are becoming resources that weren't resources 15 years ago. So it's just a benchmark to begin to look more carefully at the particular structure.
Okay, thank you. That's all the questions I think we have. Now we'll open it up to members of the public. Can I get a show of hands of how many people actually want to speak today? Okay, I would ask that you two keep your comments limited to the issues that are in the EIR or about the process. We're not talking about the actual ordinance. We're still months away from coming up with a final ordinance. So if you'd like to make comments, please come forward. Good morning.
Good morning. Kevin Collins. I live in the 5th District, and I know the board has been hearing about this issue to the point where you're probably sick of it, but those of us who merely live in this county and don't intend to grow pot commercially, now it's our chance to have something to say about this, because it's reaching the point where you're getting ready to write an ordinance, as far as I can tell anyway. And fortunately, from my perspective, the ordinance still includes its final clause, which is the no duty to enforce clause. In other words, the county is asserting that it is under no obligation to enforce the ordinance, and that anybody who tries to bring a legal case against the county for non-enforcement as a result of, say, their house being burned down is out of luck. I know this to be legal nonsense, but if you want to keep it in there, all the better, because the more people that read it, the more people will understand that the eagerness with which the planning department and the licensing officer may have toward this job appears to be somewhat insignificant, or at least not up to the task here. We have, through conversation with the sheriff, I was told that there are at least 1,000 sites in this county. Now, if that's legal, illegal, just that many sites grows. These are mostly conducted through aerial surveys. And I'm going to go straight to what would happen on my parcel. I live on an RA parcel. It's more than 2.5 acres in size. that would make me eligible to set up a cultivation business on my land if I were to choose to do so under the more permissive alternative. To do that, in order to get enough sunlight, I would have to fell probably 4 or 5 times as much of the redwood forest as I would intend to grow, simply to get the angle of sunlight onto that ground in order to get a good, strong crop. So these ideas that these impacts are mitigatable, are insignificant after mitigation, to me it's ridiculous. The use of rodenticides in steep terrain in the winter, that stuff is going to flow within a couple of minutes into your drinking water supply. Everybody that grows pot uses rat poison. I'm noticing the loss of owls and hawks around me because they're being killed off by eating rats that have been contaminated by their consumption of rat poisons. And there's many other species of wildlife similarly affected. So,
Thank you.
anyway, to start.
Thank you. My name is Valerie Corral, and I'm sure I'll have more comments. But I just listening to the impact on our environment and the immense amount of work that's been put into this brings to mind the kind of impact that's happened on this agricultural community that we live in, and also the kind of the impact that has been brought on our community by the wine industry and other agricultural industries that we have. And also bringing people over that now reside here, but who are in the tech industry over the hill. And I'd like to see, if it's possible, I know that you have much to deal with, but to bring these broad sweeping impact that it has in our community to other industries, and to really look at how deeply our community is affected, and that not only by cannabis, but by the greater impact of traffic and the means by which we can serve our community better, at the same time grow and keep revenue. So it was just a comment.
Thank you. Good morning.
Good morning, Becky Steinbrunner. I'm a resident of the Aptos Hills area and have firsthand seen the devastating effects of a required indoor grow overlay in the 2nd District. A house in my neighborhood caught fire and burned down completely the house next to it because they were growing indoors and overloaded their electrical circuits. So I want to make sure that this 2nd District overlay to not allow outdoor grow is eliminated. And it disturbs me to hear that the planning department is feeling that most of this growing will be done indoors, that will greatly increase energy use and potential threats to the rural areas for electrical safety. As you said, enforcement is the big deal, and I don't know how all of this oversight and assessment, pre-licensing assessment, will be able to be accomplished given the current status of staffing as I understand it is now. So I really think that we've got to make sure that if we're going to do this well and to protect the environment and the people who are trying to do this well, you know, we've really got to give a nod to them too. That we've got to really be fair and enforce the law uniformly. I didn't see anything mentioned here speaking about the 2nd District overlay restriction on outdoor growing. I also did not see any mention of the 1 mile north coast buffer where no growing would be allowed, and that needs to be discussed. I have issues with assuming that 75% of the greenhouse cut flower industry will now become cannabis growing. I remember that in the Pajaro Valley there was, and maybe this is part of the changes that are coming, we were going to limit that to 10% conversion so that we do support our other broad-based agricultural crops in our area. I also, because of the comment, the sheriff doesn't always know if it's legal when they show up. Well, you know what, the neighbors don't either. So I want to know how it will be posted that someone is in fact legal or not. I want to know that that will be publicly available And I also want to make a comment about the fencing in wildlife areas. I've seen these grows, and the fences that are put up greatly disturb the wildlife patterns in search of water and predatory. I've seen a fawn impaled on a fence because it couldn't make it through, and I don't want to see that. So I applaud the permissive venture that vegetative fencing will work and can be approved. I also thought the 50-year term on historic was interesting. It's going to overload historic resource
Thank you.
planner that is only one. Thank you.
Good morning.
Good morning. I'm Jim Coffis. I'm from Ben Lomond. I just want to commend the board and county staff for putting together what I believe is probably the most comprehensive look at this issue that's been done perhaps in the state. Supervisor McPherson mentioned how all the counties, and for that matter, all the local jurisdictions, cities as well, are grappling with this issue, and to date there have been 3 environmental impact reports, draft reports released, and ours is by far the most comprehensive, and so once again, kudos to you and the staff. The other issue that I would talk about in terms of the adequacy of the document was that I was disappointed that there was no, or there was very little attention paid to residential grows, and particularly given the fact that they concluded that bringing in existing growers into the regulated market was was the least had the least environmental impacts. I think that by not taking a look at what's happening in our zones was a mistake, and we'll be making our comments about that. So thank you.
Thank you. Good morning.
Morning, Pat Malo. So first I'd like to say I'm very excited. We finally got to see the EIR, and from my perspective, it said what we at the C4 and myself have been saying the whole time, is that the answer to the unregulated mess of cannabis is a healthy, regulated system that incorporates as many people as it possibly can, so that we don't have the unintended impacts of what people are doing when they operate outside the law. And I think that's really the historic aspect of this EIR, is it's maybe one of the first that doesn't study these issues as new issues, but really is studying a solution to an issue that is unregulated cannabis. And that issue not only affects neighborhoods and the entire community, it also affects the people who work in that unregulated industry and make their livelihoods through it. Which brings us to the second point of what I was too shocked at the seeing that 7,000 job creation number, but I like to joke that I probably know 7,000 people who are working in the cannabis community right now. And so we're really not talking about job creations. We're talking about a social emergency of people who are making a livelihood in one way, and the need to be able to transfer that unregulated industry that, for better or for worse, is taking care of many people in this community into a positive regulated solution. And so that's where we get into that. The more, I say that we could look at this process in 2 ways. We could look about it as, how many people we're choosing to regulate, or we could look at it as how many people we're saying, no, you're not allowed to be regulated to. And the more people that we're saying, no, you're not allowed to be regulated to, we're either saying, you better be so privileged that you don't need to work, or welcome to the black market. And so I would also, like to say, as Jim touched on, by not looking at residential, that's where most of these jobs are right now. And, one of the funny things that I see in there is that the transportation to these job sites is the biggest unmitigatable impact. And I don't even think I need to say the next part of it, that there's no transportation when your job is at your house. Thank you.
Thank you. Good morning.
Good morning. I do apologize. I want to be able to comment and weigh in on the political issue. I think sensible
Well, it's
regulation.
not the political issue, it's the EIR.
Oh, yeah, the issue. So I want to be able to say that sensible regulation is important. Members of the community deserve that. And then also, it just has a medical cannabis user, right? We need cultivators. You know, I want to say this, I suffer from PTSD and it's real. The cannabis really helps me just mellow out, really makes me chill, and it just helps me get through my day. And, you know, having people that are able to cultivate, I think it's a good thing because, you know, I don't have to go on the corner. I don't like dealing with drug dealers. I don't like dealing with people. I try to do it above board and come at it right. And I would expect the board to just move in a progressive fashion that's going to be able to support sensible regulation. Then that's not going to overwhelm the cultivators, but sensitive enough for the environment. A lot of the civil society activists that came out and speak, I really admire them. They're speaking on the environmental issue. Be sensitive towards that. We need that because, you know, this is a beautiful county, and I love being here. I'm trying to heal myself, and smoking the weed really helps. Thank you.
Thank you. Good morning.
Good morning. I'm Jason Mathis. I really am happy to read what the EIR has concluded in general. It's been something we've been saying for quite a while, is that if we bring folks into the regulated industry, we're going to get rid of a lot of these other issues, including the environmental impact issues. That is exactly what I'm seeing. I haven't read the entire report, but I do intend to get through it. And the lower parcel sizes being allowed into the system, even residential grows being allowed in the system. I hear Oakland is actually looking at permitting residential grows and allowing folks in certain circumstances to have a permitted indoor grow or a permitted, you know, bakery or something of those lines actually in their residence. We want to see as many zones allowed as possible. Timber production, you know, certainly needs to be something that's allowed in the regulated market. And this is all because it's going to mitigate the negative impacts of the unregulated cannabis industry, which we're hoping that we're going to be able to transition this county into the regulated industry. I usually, you know, if there's a comment you hear and you just know it's so absurd, it just doesn't need to be commented on or responded to, but we all know that cannabis growers don't all use rodenticides. I just had to say that. That's absolutely absurd. It's actually the reason why I didn't have my suit today. I came home and there was a rodent in my house and I cleaned everything except for the suits. I'm sorry, I'm gonna go get them to the dry cleaner. But I don't use poison in my house. I use traps. I'm very serious about getting rid of rodents. It's a disgusting thing. You don't want them in your garden either. But I really don't want poison. I don't like poison. And we don't want it in the water system either. And so cultivators are every bit as concerned about the environment as any of you. And I think we're really going to be able to work together. I tend to get back more on the scene. I've been very busy. But we're going to start organizing the community to make sure that we get a good ordinance here that everybody can agree with. So thank you all for your hard work in producing this. Okay.
Thank you. Good morning.
Good morning. Brenda Chadwick from Aptos. I do want to echo what other people have said this morning, how much we appreciate the county and the board working towards marrying what's coming, what's in the future for cannabis here in the county. As far as the report, I was a little bit disappointed that there wasn't any real inspection, or I don't know if that's the right word, about residential cultivation. I was thrilled to see that home occupation, which is something I've been vocal about for the past almost 2 years, did make it in the manufacturing side. I'm an urban farmer. I have a very small cultivation site at my home. I use all the best practices. I think there are hundreds and hundreds of more cultivators in the county like myself, but they didn't feel that they could come forward because right away you feel like, oh, we're not included. So I would like to continue advocating for home occupation cultivation because it's already going on. If you can cultivate for personal use in 100 or 200 square feet in your home, what is the difference between cultivating and being able to sell that? And I also would like to comment on the transportation part of it. My gosh, how many thousands and thousands of trips are made into the county every weekend from people coming to enjoy our community? And having an impact fee for transportation just for cannabis, I think is ridiculous. Thank you.
Thank you. Good morning.
Good morning, Marilyn Garrett. I always appreciate the public comment and information I gather from people who come to this podium that I didn't know before. Since this is a draft EIR, I don't know if there should be provisions for organic, because hearing about rodenticides used, that's going to go, of course, into the environment, into the plant. There's no way when you use poisons of any kind that they can be contained in one tiny place. It just doesn't happen. It goes all over. So no poison. I'm disturbed about the big business aspect of this, because I see often when there's huge economic interests, that other interests having to do with the environment or small growers tends to get trampled in the process. Wildlife impact is a big problem. There's already so many environmental impacts that are disturbing nature, from the wireless microwave radiation to logging, cutting the trees, to fencing. The wildlife is very diminished, not only here, but globally. Water use is big. The problem of electrical use. We're always talking about saving electricity. Of course, all the wireless stuff constantly going. Growing inside instead of using outside from the sun. Of course, there's going to be an increase in electrical use. So I hope you take seriously the comments and recommendations of people who have spoken, like Kevin Collins, Becky Steinbrunner, to incorporate your EIR to assure more environmental protection. And I often see in general, coming here since 2000 to meetings, I often read negative declaration on environmental impact report, basically saying, oh, there's no problem here, when in reality, there's a huge problem. So those are my comments. Thank you.
Thank you. Good morning.
Morning. My name is Alice Terrell. I have two major areas of concern regarding this report. One is what the woman who just spoke before me said. I would like to see the new regulations that go into effect not have any pesticides and rodenticides used. It makes sense in this county that we do as organic as possible. and you have the opportunity to do that with these new regulations. The other comment I wanted to say is that I think that there's been a lot of focus on this report in what goes on in the mountains. And we have a whole lot of agricultural land in La Selva Beach area and that area. And the environmental impacts for creating more cannabis cultivation, commercial cultivation in those areas has a great deal less problem. There's a great deal less problematic areas. So I would like to see the possibility of different areas or different landscapes being treated a little bit differently from each other. Thank you.
Thank you. Is there anyone else? Seeing none, there's no action required on this. I want to express again my appreciation to the board. I mean, to the planning department, our cannabis licensing staff, our agriculture commissioners, and I look forward to all the input we will receive on this, not only from the public, but from our commissions, and then ultimately in the board. And this highest level of environmental review will ensure that the ordinance that we do adopt takes into consideration the impact that this new practice will have in our community. So thank you for your work, and I look forward to hearing more from you in the coming months.
I have a comment, but I'll wait till.
Well, okay, I'll give you one last shot if we keep it to the areas that I just previously described.
If we look at this whole process as we've gone along, the motivation for me was medicinal marijuana in the beginning, and then recreational use has been added to it. My motivation in the beginning was protecting the beautiful environment we have in Santa Cruz County. And what we have to be very careful about, we did have a question earlier about jobs and how that, you know, we have to get jobs in other areas. We have to protect our environment here in Santa Cruz County. And if this cash cow gets too big, where tax money is coming in and feeding our general fund, we're going to get addicted to this whole process. We have to be very careful that it doesn't become the motivation of tax money coming in and jobs coming in this particular field. We have to protect the environment. We have to look out for what we have. And as we've gone along, District 4 has gotten a lot of more permissive use in our area. There's more restrictions in other areas, but I'm looking out for District 4. I'm looking out for neighbors that are afraid of what their neighbor is going to do with their marijuana growth and how close we're going to be permissive to allowing them. How close can you grow next to your neighbor? How close can you grow near a school? How close can you grow near a church or whatever? That's what my concern is. The money is if we're not careful, money is going to become the number one motivation here. My concern is the environment, redwood trees, ag land, neighbors being able to live next to a neighbor that's growing and not have to worry about the odor, not have to worry about how they're growing it and whether or not they're going to cause a fire and all that. So that's my concern. And I'm looking out for District 4, and I just want to make sure that everybody knows that. And that's in these 600 pages. Actually, there's enough in the 600 pages. We can talk in just about anything. We can bring anything up. But my questions are the environment, not the money.